Hello, hello. Well, hey, Facebook, how you doing today?
Hey, everybody. This is Judah Hoover and my co-host, Josh Weidman. We are coming to you with the Build and Grow with Real Estate show here on the Real Estate Hackers Network. We come to you every day at noon for about half an hour of some relevant content. This week, we've been talking about how to take advantage of the coming hold off on evictions and the potential foreclosures and difficult times and potential dip in the real estate market that's coming because of that. But we also are talking about the responsibility that we as landlords and investors have to be good players. And this week we have an attorney in the Harrisburg area, the capital market area, who I have known for, gosh, David, probably 10 years now, if not 15 years.
15 or more, yeah.
Yeah, so David Lanza also, not only does he work with my group, the Landlords and Investors Mastermind group, he also is like he can tell us exactly, but he's like when we give him a chance to introduce himself, he's like the legal affairs chair with Carpoa, which is a membership organization for Carpoa is the Capital Property Areas Owners Association. I forget exactly what it stands for, but and they kick part of their dues upstairs to PROA, where they fight, which is the PA group by a similar designation, and PROA helps support lobbyists to fight rules and laws and restrictions that would be onerous to landlords, but work with legislators to come up with fair middle ground and compromises, what we can do, and things like that. Well, and Rita, who's a friend of mine, has been great with that organization as well.
Dude, you just went right into it. Right into it. Before we jump in, David, I don't mean to put you off here, but I like we have new viewers.
I'm telling people that we've got a guest today, and I'm excited about it. Can you tell I just had a cup of coffee? I just had a cappuccino and an espresso. Can you tell that I'm a little bit amped up?
This is why I don't drink coffee.
Judah, why don't you start by introducing yourself?
Okay, so my name is Judah Hoover, and I am a real estate investor and a executive in a property management company, and I also have my real estate license. So the great thing about working with me, I was just talking to a nice young lady yesterday, and she was like, hey, I'm not sure if I want to sell my house to an investor. I'm not sure if I want to list it with the realtor. And I said, listen, the problem is investors are all going to tell you to take a low ball cash offer, and realtors are all going to tell you to list it on the MLS, and they're each going to be able to tell you why you should do that, but they're not going to be able to war game pros and cons and actually be able to come up with a good situation. So this young single mom, 30 years old, father died, left her with the property. She's the executor of the estate. And I'm able to actually come involved and kind of talk to her the pros and cons of taking a lowball cash offer from an investor, and also the hassles of listing it on the MLS, but to get more money that way and come up with a solution that's better for her. So if you want somebody who can guide you through real estate transactions, no matter what might come down the pike, give me a call and I can help you. 717-766-7994. Josh, who the heck are you?
Thank you, sir. My name is Josh Weidman. I am a real estate investor and also a hard money lender. If you are somebody that's looking for funding on your next project, I think you got in there. Judah, can you hear me?
Yes. Yeah, I can hear you.
Background noise on you. Anyway, sorry. My name is Josh Weidman. I am a real estate investor for the last 14 years. I'm also a hard money lender. If you're looking for funding on your next project, Hard Money Bankers is a place to go. We are a direct lender, which means when everybody else ran out of money because the banks stopped funding right in the midst of COVID, and when the institutional funding dried up, we've been lending throughout that entire period. We're a direct lender, which allows us to underwrite your deal in just a few hours, give you an approval the same day you contact us, and then we can close within 24 hours. So long as title's done, your ducks are in a row, we can get you to closing quickly. So if you have a project you're looking to get funded, or you've got a lender that backs out at the last second, or you've got a deal that is a banging deal, but you need to close tomorrow, give me a call. You can reach me at 717-213-8488. We lend in Pennsylvania, New Jersey, Delaware, Maryland, Northern Virginia, and DC. Now, David, I am so glad you're on here today. We've been talking about, we've been talking about evictions and like this coming wave of evictions across the country. The number just keeps growing and growing and growing. But we've been looking at it from a bunch of different perspectives and talking about it, how to, make money off of it when evictions start opening up, how to, some options to fix this problem, hopefully before it crashes the entire economy. And now, I'd like to welcome you, and I'm glad you're here, just to kind of give us another perspective on really what's going on in the state from a legal perspective, and what people should know if they're looking to evict, and what are some of the repercussions that maybe Judah and I haven't seen as we've been discussing this. But first, let's start by
I was
talking.
going to say that was 18 questions, David. Feel free to take them in any order you want.
That's exactly right. That's exactly right. You take them wherever you want to go. Tell us a little bit about yourself. Let's start there.
All right. First of all, I am a real estate lawyer. I've been practicing in Central PA for a long time, decades, it seems. It actually is decades. I handle evictions and all aspects of landlord-tenant law, plus closings, title insurance, settlements. There are some aspects of settlements and title insurance that are unique to landlords and property investors, and I am aware of those issues as well. I can help you solve problems before they begin, before you get to the point where you're facing a very difficult eviction. Much cheaper to do it early, or to solve the problem early than later on. I'll put it that way.
Yeah.
Now, to answer one of your questions, you were talking about a wave of evictions. I'm open to data and facts about this, but what I'm hearing from my clients is that most of their tenants are still paying very high percentages, very close to what it was before. It may not be that way for everybody, but that's generally what I'm hearing. Mm-hmm. Although it only takes one or two bad apples to really kill your profits from the rest of your tenants. I'm aware of that, and I'm starting to hear some of the bad stories and starting.
Yeah, David, let me just interrupt to say that's very much what we've experienced as well. And I think the media is really blowing it out of proportion. We manage about 4,000 properties across 4 states, and we've only seen a 2% reduction in rent collection. Okay. So, but also we've been very proactive, helping people get their unemployment, telling people, hey, you might as well pay because we are eventually going to be able to evict. Now, if it keeps on being pushed back, I don't know that is going to continue. But for right now, we are still collecting rent at a very high rate. And the other thing that I would say is this, I completely, I checked with the person who handles our evictions, because when you manage 4,000 properties, we have an eviction eviction filing team. There's 2 ladies in our office that's all they do basically all day, every day. And they said it is a little bit higher, but we have 3 times the number of evictions filing for 1 month than what we normally would, but it's because we haven't filed for 3 months. You know what I mean? It's not anything more than just a backlog of what we're seeing. So I just wanted to say, I agree with you, and we've seen similar data.
And I would say too, then I guess I'd summarize by saying the problem is containable if this doesn't go on too much longer. If they extend the eviction moratorium beyond the summer into the fall, into next year, then I don't know. Yeah. I would submit also what you're talking about as far as helping your tenants, nursing them along. This is what the umbrella landlord organizations recommend. PROA, which you mentioned, National RIA, which is the umbrella over many of the local groups, they specifically recommend nursing your tenants along get what money you can while you can, and then limit the damage until you get to a time when you have your remedies back. So we fully endorse that.
Yeah, David, let me ask you a question. And
Yeah.
we try to stay apolitical here on the show. We don't necessarily do that great of a job at that, but we certainly make an attempt. You even have a bigger segment of the population of landlords than I do because of your involvement on those larger committees. I've always thought by and large landlords do the right thing and try to help tenants and aren't the greedy landlords, the money grubbing, deep pocketed individuals the way they're portrayed on the media. Would you agree that by and large landlords operate with compassion for their tenants and have sympathy for what they're going through and try to come up with fair middle grounds?
Sure. The experience I've had I've been with Carpoa 26 years, other groups, that the experienced landlords, the ones that know what works, they are creative, they are fair with their tenants. I hear many stories of landlords working with their tenants to solve problems, and this goes back long before this year. It's the ones that are looking to get in and out real quick and don't have an understanding of the business, and those I really don't deal with very often. Once in a while, we're cleaning up their messes.
Yeah, cleaning up their mess. That's what gets expensive. It's amazing how much less expensive it is to do things the right way up front.
Yeah.
Try to clean up the mess after the fact. So, David, you mentioned something before we before the show, and we were going back and forth with email. You mentioned that you're seeing that there may be some, I don't know, ancillary effects to this moratorium and the shutdown related to municipal inspections beyond just the eviction crisis.
Well, for those municipalities that have passed inspection ordinances or those that have proposed it, for example, I in one municipality that had proposed an ordinance, and as long ago or as recently as early this year, they were expecting to have it adopted by now and to be starting the inspection, and it's off the table. And I'm sure the reason is because they don't want to take any more chances with this virus. Most of the municipalities have stopped having in-person meetings. They may be starting up again by now, but they're all very careful. If you go to the borough offices, they're all wearing masks. I have a hard time believing that they're going to be willing to send their code officers from house to house in the entire borough, one of these larger boroughs or even the smaller boroughs in central Pennsylvania, potentially spreading this virus after they have done so much to be on the front lines of warning people of the dangers of the virus.
One thing that really surprised me, my background, most of my investing background is in the Philadelphia market and suburban Philadelphia area. And I've begun, I've begun my search for some investment properties here in central PA. And in that process, I've been reaching out to local municipalities to just kind of get the feel for, what they require, what they're looking for. It surprised me that so many municipalities were just talking about implementing, pre-tenant inspections.
Mm-hmm.
And implementing some oversight in Palmyra, where where I'm located right now. I couldn't believe that they've got a they just have a registration, and it's essentially a non-inspection rental license, I guess. But it just was surprising to me that this is kind of a new thing. When you look at the cities, they're a lot more engaged, I guess, in some of the inspections and at least licensing for these landlords. Is this pretty common across the mid-state that these smaller
large municipalities like Harrisburg, Camp Hill, York, Lancaster, Columbia, if it's a pretty big municipality in central PA, they're going to have something like that. And David can also speak to this, but most of these little towns and boroughs and townships and things like that, maybe they want you to register, and maybe there's a $25 annual fee or something like that, and they've got the ability to inspect, but it is very, very infrequent that they even enforce anything or try to do anything right now. The larger populations, like I said, Lancaster, York, Harrisburg, sure. It does not surprise me though that Palmyra did have, was moving forward with something. That's been pretty common. Would you agree with that, David?
Yeah, my experience has been it's mainly the boroughs, the older boroughs that have inspection ordinances. The townships, the larger townships, the more prosperous townships don't seem to have any desire to upset the apple cart, upset the prosperity they have.
Yeah.
There's exceptions to that. Right now, I don't think anybody. Well, I take that back. Most of the municipalities with the programs are not doing them, but some apparently are talking about reinstating the program at some point soon. I think they're going to be happy to just continue collecting the money and not do the inspection. My recommendation, and I haven't really come up with a plan on implementing this, but I think at some point we have to begin opening dialogues with some of these municipalities and telling them, hey, can't we put a halt to these inspections as well as putting a halt to the fees until we see where this whole thing is going? I think the issue, the virus as an issue, I'll put it that way, the virus as an issue is not going to go away. I think we're going to hear about it seasonally from year to year, like we hear about the flu, like we've heard about other viruses. And I don't think the powers that be, so to speak, are going to be able simply to put the brakes on and say, all right, we're now normal. The virus is no more. There's never going to be a declaration that the emergency is over and everything's fine.
Right.
And it's going to be a question of what amongst these restrictions and limitations remain. And I think there's got to be a possibility. There's got to be room for convincing them that given how proactive they've been in pushing the issue, mainly it's from government, municipalities, other agencies. They're the ones that are most proactive about, first of all, shutting down, insisting on masks being worn inside their buildings. I think they would have a hard time saying that on the one hand, and on the other hand, saying it's okay for their inspectors to be in harm's way. We don't know what has been festering inside these homes. People have not been able to leave their homes, or at least they were not until recently. We don't know what has gone on inside the homes, what kind of conditions there will be, and having a code inspector going from house to house, potentially spreading this throughout the entire municipality.
David, you've been an attorney for 25 years in Central Pennsylvania. You're 30. Okay, great. So you've been I would think by now you would understand that politicians are very capable of intellectual dishonesty, are very capable of inconsistencies in their logic. I mean, they are, if there's one skill that it takes to be a politician, it is not to have a linear thought process.
Well, that sadly, yes, they will say one thing and do another depending on their convenience or their need to raise money.
Yeah.
They'll shut down their borough office one day and the next day be undertaking steps to raise money.
Yeah.
So, but I think what it takes those of us in the business to come out and attend these meetings. And I know, Judah, you've done this with me. We've been at Harrisburg together, and there's a bunch of others that I've been to and other investors have been to. If we make enough of a fuss at these meetings, I think they begin to back off. And it's surprising. The last few years, some of these municipalities have actually worked with us and compromised on a few issues and given us something a lot more reasonable than what was coming out, say, 10, 15 years ago.
Yeah, absolutely. I completely agree with that. Hey, let's shift gears here just really quickly because I want to get couple questions answered on the record here that I'm sure people have tuned in to check out. By the way, if you are one of our regular listeners, we greatly appreciate you, and we thank you for checking us out. And we Josh and I do this show for you. We don't make any money off of this. This is for the listeners to develop content, because we can't meet together and we can't have local real estate investor meetings. So we started doing this show, and if you are a regular listener, we just really appreciate you, and please feel free to like and share this show. David, my question to you is, if I have a lazy POS tenant who isn't paying rent and is also maybe doing some damage, and yells racial slurs at the neighbors, and has a dog that's too big, and scaring the children on the block, how many of those things have to be true before I can get rid of a bad apple? And what process do we have to go through? Because I know that it's a moratorium with exceptions. Are those exceptions in name only, or what do we talk to me about this?
Well, we're getting them to work. It just takes us to be proactive. And forgive me if I go over territory that's already been discussed. I'll just summarize.
No, you have not. We've specifically avoided specifics because we're not attorneys.
Okay.
Right. There we go.
Well, I'll be brief on a couple of these points, and you can ask me for more specifics if you like. As we all probably know, on July 10th, the governor extended the eviction moratorium through August 31st.
Right.
And it does contain exceptions, and there's a specific exception for non-rent violations. If your tenant is violating the lease in a way unrelated to rent, that is an exception which allows you to file an eviction complaint. And at the same time, and this is not as well known, but we know about this, and I have documentation of it. As you might know, PROA, which is the organization you mentioned, the statewide organization, they do have a lawsuit pending against the governor to lift the entire moratorium. And it's not yet been decided. It's pending in the Supreme Court, but there are communications back and forth between PROA attorneys and the Attorney General. The Attorney General wrote to the PROA attorney on July 10th stating there's another exception to the moratorium, which occurs when your lease specifically waives the notice to quit. If you have a waiver of notice to quit in your lease, you can seek eviction for any reason.
I didn't realize that was even.
I did not know that, David.
Yeah.
I have a waiver of notice to quit in all of my leases.
I'm holding the email from the Attorney General's office. Now, this is the Attorney General, of course, is the governor's lawyer. So if the Attorney General says something, it's binding on the governor, especially in the context of the suit. Now,
David, this is revolutionary.
Okay, so let's back up a minute.
Okay.
Let's dumb this down even to the point where it's almost going to be grueling.
Okay.
Can you give us a step-by-step,
All right,
aside from COVID, of the eviction process? If I get a tenant that is not paying, what do I do? Put them outside of the COVID moratorium at this point, and then we can kind of go back and circle back. Okay.
So the way it was before the moratorium, like last year, you have a tenant, you've decided, you've worked with them enough, they're not going to cooperate, you want to evict. If you have a waiver of notice to quit in your lease, you can go right to the district justice and file a complaint. However, there's always a caveat I put in, because some of the district justices don't recognize the waivers, because the clerks are the ones that run the show sometimes. You go to the desk, they say, we're not taking the complaint unless you show us the notice to quit. So I often tell people, just put a 5-day notice on the door. Take a picture of it, and then you'll have it with you in your hand when you appear at the clerk's desk at the district justice office. So sometimes it pays to do both. The extra 5 days really won't hurt you, and it'll avoid a lot of hassle. Yep. The current situation, just to finish that train of thought, assuming you get in front of the DJ and you have your hearing, you can get.
And that usually happens. So usually in Central PA, that happens about 15 to 20 days after filing. Sometimes as short as 10. But
between 10 and 14 days.
Right.
by statute. Usually they're pretty good about that.
Yep.
You get your hearing, assuming you win, and this is important too. If you'll have your rent, unpaid rent, plus you have your non-rent violation, usually noise, some of the things you mentioned, some damage to the property, failure to buy, renter's insurance, any number of things. There's smoking in the building. It's important to include those. It's even if they've written you a bad check, that's a non-rent violation. That's a separate issue. It's important to list them because that allows the judge to give you what's called straight possession. You get possession regardless of whether they pay you in 10 days. If you get a pay and stay instead, they get 10 more days to pay you and then they can stay.
Okay.
If you get straight possession, you have the option of whether to enforce it or not.
Got it.
Now, to finish up that discussion, if they appeal, they have to put money in escrow with the pathonetary. That's why it's important to make sure you get as much money in your judgment as possible. Make sure you tell the DJ the monthly rent, the total rent in arrears. Don't ignore that because you just want possession. You don't care about the money. You'll never see the money anyway. A lot of landlords say that, and it may be true. But if you don't have numbers for the unpaid rent, for the monthly rent, rent in arrears, they can appeal to the pathonetary of your county for free.
You should also bring a ledger. You should have a ledger, even if it's an Excel spreadsheet that you've kept or whatever. If you've kept records, they're assumed to be right unless the tenant has records that are contradictory.
Yeah.
And I have never, ever seen a tenant bring their own records. So therefore, the judge assumes that your records are correct. The other thing that I like to tell people is, I mean, it's like 1 to 2% of the time people appeal in central Pennsylvania. We manage a bunch of properties in Philadelphia and Trenton, and those have a higher appeal rate. But do not be afraid to file because, oh, well, they can just appeal anyway. Appeals are actually pretty rare.
And I think the reason they don't appeal is because they know they have to pay the money to the pathonetary if you've done it right.
Yeah.
And to support your point on having a ledger, in my experience, the judge may not even look at it, but if he knows you have it, and if it's not your only eviction before that judge, you will build up credibility if you have your records in order. We've had guest speakers at Carpoa. Sometimes we have the district justices come, and they say the only thing that sometimes landlords bring are their car keys and their phone. You need to have some documentation, your ledger, your lease, and a separate piece of, I always do the separate piece of paper that says, it has 2 lines on it, rent in arrears and rent per month. The judge has a form he has to fill out where he fills in the blank spaces. And those numbers are the blank space, rent in arrears, rent per month. Once he fills that in, that goes into the system, and the pathonetary will see it if they try to file an appeal. So it's very important.
Rent in arrears, by the way, rent in arrears is unpaid water, sewer, trash bills, unpaid late fees, anything that you want to charge to the tenant, like if it's part of your lease, that if they're responsible for grass cutting and they didn't cut the grass and therefore you got a $50 fine and you treat that as unpaid rent. Now, sometimes judges will force you to back that all out, but you want to count as many things as unpaid rent as what you feel that you are owed. Don't just have it be whatever rent is owed you. Also include late fees. Also include everything else.
I agree, and I have seen judges. It sometimes it creates confusion with the judges. How much of this is for this? How much is for that? How many months? If you have the monthly rent and then the rent in arrears, he'll ask you how many months are they in arrears, and he sees he can't do the multiplication because you've added late fees and sewer. As long as you get a feel for your judge, as long as he understands and you can explain it, then that's fine. If it's going to cause him confusion, it's something you got to learn to play by ear for each particular judge. I've had one in particular that would not allow me to include attorney fees as rent in arrears, even though he awarded the fees. He awarded an extra $500, $1,000, $1,500 attorney fees but they won't put it in that magic number, rent in arrears.
Sure.
But you can live with that as long as the number is the true number. It's probably been at least a couple. It's enough money in the rent in arrears that they can't make it up easily.
Right.
If you
And,
want
and this is
that's important.
this is one of those things where it's a guiding principle. I mean, I'm an aggressive, hard-charging individual, but I also temper myself with the principle that pigs get fat, hogs get slaughtered. You know, so you want to bump that number up, but you do not want to be ridiculous about it.
You want
If
to
it doesn't,
easily
if it doesn't
explain.
pass the smell test, you're doing yourself no favors.
You ask yourself, can I explain it easily? In 30 seconds or a sentence or two. If you can explain it, then go for it.
Yep. That's
And
great.
that basically is the outline of your seeking an eviction at the district justice level and the potential. If there's an appeal and they have to pay the rent to the prothonotary, you can file a motion, or your attorney can file a motion with the court to get the money out from time to time. If they don't make a payment, you can get the appeal short-circuited very easily without a hearing in front of a judge. If they miss a payment by a day or two, the appeal still goes on, but you can get possession.
Okay, so let's circle back around to this, David, because I mean, and I need to talk to you about this. So you're telling me that I can file for eviction on the hundreds of people that I need to file for eviction on, because more than likely my lease carries a waiver of notice to pay rent or quit.
Well, that is what the email from the Attorney General says, but it's not that simple. We have managed to start getting the eviction process started again over the past month or so, but it comes at a price. So I shouldn't say it that way. It's somewhat difficult because the personnel at the district justice's office are not always aware of these exceptions. And so
that is a very charitable way of saying that, David. I commend you for your excellent lawyering there.
And I'd actually like to talk a little bit about that, because my experience with that just recently gives me kind of an idea as to what to do to get around that. And we're not aware of exactly everything that's gone on behind the scenes with the moratorium, but apparently the chief judges in the counties have followed up the governor's moratorium with a separate order to the DJ saying no more evictions until either until the emergency is over, till August 31st, till further notice, something like this. So when you go to the DJ's office, or if you call them, and I think this is a mistake, if you're a landlord and you call the DJ's office and say, "Can I file an eviction?" the answer is going to be no.
Right.
That's what we're ordered. Our order says no, and that's it, and that's all they'll tell you. They won't say, "Well, here's some exceptions." And I think what you need to do, and this has worked, go in person, even if just for the filing. I'm not even talking about the hearing. Go in person for the filing, and bring the paperwork with you. I have a copy of the Attorney General's email. I have a copy of the governor's order. Look on the governor's order in particular on page 3, where it contains the exception for non-rent violations. Be prepared when the clerk tells you we can't take it. Show them the language that says yes, we can. And it's still not automatic. In one situation I had, when I started quoting page 3 of the governor's order, they knew immediately what I was talking about, and they just hadn't revealed that they knew this.
Right. They were playing dumb until you tipped your hat that you are not dumb either.
So they started asking, so has there been violation? Has there been too much noise? Was there a dog bark, etc.? I said, yes, we have non-rent violations. And they said, okay. Or actually, what they said was, and this is important, they said, we have to contact the chief judge. We have to contact the office in the county headquarters that sent me the order denying our ability to take these cases. And they did that. They contacted the chief judge and got back to me later that day and said, okay, we can take the complaint for possession, but not for money. That's what they said. So the second step in this process was we actually filed a complaint, and you've seen the DJ complaints. It has the spaces for the money. We
Right.
still goes in anyway. And they said, well, we don't want to take that. We can't put the money in because the order from the governor says only non-rent violation. But the DJ said, no, that's okay. Put it in, and we'll argue it at the hearing. And I think that's a good step if you can get past the clerk to the point where you can discuss it at the hearing. And it's important at the hearing then to convince the judge, put the money in the judgment too, because the way I read the governor's order, it says specifically in the order, rent is not forgiven. Nothing in the order forgives rent.
Right.
And I think my opinion is if you can use the non-rent violation to get into court in the first place, and that is a sufficient enough reason to evict the tenant, then they could add the money judgment on top of that also. Especially, there's been a lot of common sense arguments made on our behalf, at least in the discussions I've heard. Well, they were behind before. They didn't lose their job. The COVID didn't cause them to be in default. If you can get in front of a judge and make those arguments, I think he will let you include the rent as well as the property damage in the money judgment, and that makes it easier to enforce. And in fact, it just happened yesterday. We had a judge award $3,000 in addition to possession. But the point is,
dear listeners, Dave Lanza's contact information has been scrolling here for a while. If you haven't figured out by now that you need to call him whenever you have any legal questions about, the thing that I've always liked about you, David, and I hope you don't take offense to this, is most good attorneys don't play at the level you play, and most attorneys who do play at the level you play aren't good attorneys, if that makes sense. You're one of the few really awesome attorneys who works at the district justice office and isn't like, well, as far as I'm concerned, you're a good enough attorney to be a murder defender or something like that, but you're grinding it out here for us little guys in district justice court, and I've just always appreciated that about you, my friend. I think you're awesome. What do you think? I have a question here because I think we've talked about that enough, and I think that's great. As we're kind of wrapping up here, what do you think is going to happen on? Let's say this doesn't get extended, September 1st. All these district justices get 3 months worth of filings plunked down on their desk. What's going to happen after this is raised?
That predicting the future is always difficult, and once it happens, it's something where you say to yourself, well, yeah, I should have known.
Well, wait, you don't have a crystal ball in your office? What the heck?
I think what's going to happen is, like I was saying before, I don't think they're ever going to declare the emergency to be over. I think they're going to, part of it is going to be somehow transitioning back to the way it was as before as much as possible. I don't think they're just going to take all the cases at once. They're going to find a way to ease into having all these evictions if need be. I don't know how that'll be. They've said specifically they owe the rent. I don't see them backing off of that. That's a whole other issue. I think maybe they might relax the requirement to hold a hearing within 10 to 14 days. There may be special folks appointed, something like that.
So you're saying that you think that the governor's going to declare himself emperor under emergency, under the emergency.
I think they've already done that. I think we're beyond that point. I mean, we are beyond anything where anyone really expected we would ever be. If you told us this a year ago or 6 months ago, they've already.
The worst part is the Supreme Court is backing him up and supporting him. I mean, we have no checks and balances. It's ridiculous.
I don't mean to speak out of turn here, but the Supreme Court is more political than the other appellate courts in the state. So the truth is though, the pro suit against the governor in the Supreme Court has yielded some progress. We haven't. It yielded that email, and I want to see how far we can. I've not actually tested the ability to file a regular complaint based on a waiver of notice. I've not gone.
David, I mean, any landlord I know, and I network with not quite as many as you, but a whole bunch. Any landlord worth their salt for the last 20 years has been including a waiver of notice to pay rent or quit. So therefore, I gotta believe that there are some juicy opportunities out there to test that.
Well, if I can address that, as far as the opportunities for testing, we've talked about it a little bit, but this is where it's difficult. The landlords have to do this. They can't be bashful about going to these DJs and showing them the paperwork, knowing that the DJs will send it upstairs and start communicating with the common pleas judges. And at some point, the more that the common pleas judges hear this, I think there'll be resistance at first, because it does not appear in the actual order. You had a surprise reaction too, Jude. They'll have an even more surprise reaction. They're going to try to resist, but the more the issue keeps getting kicked upstairs to the common pleas judges, the more likely we are to develop some kind of protocol for allowing us to do what we need to do. And I would point out, the longer it goes without us really working to challenge this and to take advantage of the exceptions we have, the more people get into a habit of just not doing evictions. And I'm speaking of the clerks. The clerks at the DJs, the more they get in the habit of not doing evictions, the harder it's going to be to enforce the exception. And I think the fact that we've already had some success, some DJs are awarding possession. And that shouldn't be the first thing you say. Well, this other DJ awarded possession. You show them the exception, show them the paperwork when you're at the desk, and then you can add. And this is why other judges are doing this.
Right.
Yeah.
And I'll point out also, in Dauphin County especially, they refer, the DJs refer to the order that came from the chief judge in Dauphin County, which was based on the governor's order. And I have an order from that same chief judge in a particular case I had. The order came out July 16th, which was after the extension, granting me possession in a case, for my client, possession in a case that we had pending. It was started before COVID, but the order didn't specifically say possession until July 16th. And that's from the same judge that the clerks are relying on for not taking cases. So it's just a matter of building up some momentum. Takes a little while, takes some persistence, but the more we do it, the more I think and I think also this would answer your question too, Josh. If we get to September 1st and the moratorium expires, if we already have precedent set where they're taking cases and we're starting to do evictions, it will make the transition to non-moratorium much easier.
Yeah.
And it's much less tempting for the governor to extend the moratorium. Right. That's, I think, key. You don't want to have him, if everyone complies with everything he says to the letter and doesn't recognize exceptions, then this will go on forever.
Yeah.
Once they get a taste of it, they don't give up.
Well, look, David, you have given us so much information today. Like, okay. We're already running long, and I don't want to keep you all. I think we could talk about this. There's so many nuances to, getting this thing, getting the bad tenants out and keeping the good tenants in. We could continue to talk. If people want to get in touch with you, if they need a good eviction attorney, or just have a real estate a question about real estate law or whatever, how do they contact you?
Call the number on the screen. This is 730-3775, 717 area code.
Yep. Awesome. Yeah, that's awesome. I really, really appreciate you being here today. I think everybody that's been on here, we've had a ton of people watching. I think we've really I got a list of notes sitting right next to my desk here. I've been kind of quiet today.
We got to have David on again. That's just all there is to it. And when we need because issues are going to come up from time to time, and we're going to need to have David on.
That's right.
Anytime you want, we'll be happy to.
So, hey, that's it for today. Thanks, guys, everybody, for being here. David, thank you again for joining us. If you enjoyed today's program, don't forget to like and share the show. And we'll be back here tomorrow with another program talking about the news of the week. So until then, thanks a lot, everybody. We'll see you here at noon tomorrow. Take care.
Thank you, Jen.